Last summer, I convened a hearing, actually in this very room, to examine the foreclosure crisis in Rhode Island and to discuss a proposal to give bankruptcy court judges the power to reduce the principal on primary residence mortgages the way they can on essentially every other loan, including loans on vacation homes or cars or boats. This has long appeared to be the most efficient and least costly way to keep families in their homes. But the large banks, of course, have fought against it with their full lobbying might, and we have been unable to overcome the big bank-generated filibusters in the Senate. Over the years since our hearing on bankruptcy modifications, the foreclosure crisis has not relented in Rhode Island or across the nation. The administration's Home Affordable Modification Program, while well-intentioned, has not succeeded in producing enough modifications to stem the tide of foreclosures. We've known for some time that the large loan servicers play all sorts of games to slow down and derail the modification process. And earlier this month, we learned that they are playing fast and loose with the foreclosure process and documents themselves. A process that may leave a family homeless has been now relegated to foreclosure mills and robo-signers. Forget a modification. Many of these servicers aren't even providing a human being to confirm that the foreclosure is warranted and the documents are in order. How did it come to this? As a result of the securitization of home mortgages, the relationship between the homeowner and the lender was fractured, and the foreclosure process and system became dysfunctional. Decisions that make no economic sense overall get made because the fracturing has created perverse incentives within the system, because it's virtually impossible for a homeowner to find a human with authority to resolve their problem, and from sheer remorseless bureaucratic inertia. Ann Sabak is here, a realtor who has shared the suffering of numerous clients. And when she came to visit me about this problem, she memorably put the question that she hears so often this way: why is it that the bank wants to foreclose on my home, throw me out, and sell it to someone who will pay less than I'm willing and able to pay right now? Until we answer that question, we have a continuing problem ahead of us. I've called on Fannie Mae, Freddie Mac, and the Federal Reserve to use their powers to institute a national foreclosure moratorium. I believe we should freeze foreclosures until the loan servicers can demonstrate that they have new systems in place to properly evaluate homeowners for modifications, and if modification is not financially possible, to provide homeowners with an orderly, humane, and logical foreclosure process. That would seem to be a minimum standard. I hope that my colleagues in Washington will consider this when we return after the midterm elections. This subcommittee has jurisdiction over the courts, and today we will examine whether the court-supervised mediations add common sense to an out-of-control foreclosure process, and perhaps help families stay in their homes. Our bankruptcy court here in Rhode Island, under Judge Bottolato, is one of only a handful of bankruptcy courts nationwide that offer pretrial foreclosure mediation. Today we will hear from Judge Martin Glenn of the Bankruptcy Court in the Southern District of New York, one of the creators of the first such mediation program, and John Rayo and Chris Lefebvre, two attorneys familiar with the Rhode Island program. For families in Rhode Island and across the country snarled in the foreclosure bureaucratic nightmare, it is vital that we find a way to address this growing crisis. Today's hearing will help us determine whether bankruptcy mediation programs can serve that purpose, and whether federal legislation might be useful in replicating the Rhode Island and New York programs nationwide.